All right. Well, we have a nice full house here. So thanks everyone for joining us today. My name is Jamie McAvoy. I'm the Associate Director at the Water Resources Research Center. And welcome to today's webinar. Before I introduce our speaker today, I want to respectfully acknowledge that the University of Arizona is on the land and territories of Indigenous peoples. Today, Arizona is home to 22 federally recognized tribes, with Tucson being home to the Otham and the Yaqui. The university strives to build sustainable relationships with sovereign Native nations and Indigenous communities through education offerings, partnerships, and community service. Um, our speaker today, oh, I'll, let me start by saying I'll ask everyone attending to please keep yourself muted. Uh, our presentation will be followed by a Q&A, and you can enter the questions into the chat as we go along, or you can enter your questions at the end of the presentation, and we'll moderate the Q&A from there. This recording will be posted to our website. The webinar will go from 12 to 1:15, so it is a 75-minute webinar presentation. And we know some people have to leave at 1 o'clock, but if you're able to stay till 1:15, we'll have a nice, robust time for Q&A. So our speaker today is Dr. Aminta Menjivar. She holds a PhD in American Indian Studies with a minor in law from the University of Arizona. Her dissertation research focuses on Native American water sovereignty and self-determination. Dr. Menjivar currently works at the International Indian Treaty Council, an Indigenous peoples organization that protects the rights of Indigenous peoples at the international level. She aims to use her doctoral degree to educate students and the public about the importance of protecting the rights of Indigenous peoples. The title of her presentation is the 104B Grant Program Student Research Presentation. So she was the awardee last year of the 104B grant that the WRRC administers. And the focus of her presentation, or title of her presentation, is Indian Water Settlements in Arizona, an analysis of their history and potential future. But before I turn it over to Dr. Menjivar, I would like to note some upcoming events. On November 18th, we have a webinar on conjunctive water management for sustainability. December 10th, we have a co-sponsored event for Native Voices in STEM. On December 15th, please save the date. We'll have a webinar. It's going to run from 12 to 1:30 on the how of water diplomacy. We'll be providing more information and opening up registration, and we'll have more information on that in this week's Weekly Wave. And then on March 16th at 3 p.m., the Environmental Science Department Colloquium and Seminar will focus on PFAS, featuring Sharon Udison. Two more announcements on the next slide here. Also, please save the date for our upcoming annual conference, which will be held April 14th, 15th at the University of Arizona. The focus of this year's conference is commercial and industrial water stewardship, so please watch for announcements about that. And lastly, our annual photo contest, we're soliciting submissions. So please, if you would like to submit any photos, please submit those by December 19th. Okay, and with that, I'm happy to turn it over to Dr. Aminta Menjivar, who will talk to us about Indian water settlements in Arizona.
Thank you. Let me just share my slides here. Is it showing full screen? Okay, excellent. I'm
Great.
just going to minimize this over here. Well, good afternoon, everyone. As Dr. McAvoy just said, my name is Aminta Menjivar, Dr. Aminta Menjivar. I'm still getting adjusted to the title of doctor because I graduated from the University of Arizona in May of this year with a PhD in American Indian Studies and a minor in law. So the focus of my dissertation was Native American water sovereignty and self-determination. And to do that, I did a historical and comparative analysis of uh, water rights, Native American and indigenous people's water rights in the United States. And I compared the litigation process and the settlement process to determine which process would afford the most sovereignty and self-determination for tribes. So the 104B project that I did for the Water Resources Research Center is embedded within that broader project of my dissertation, which is why you're going to hear me talk about sovereignty, topics of sovereignty. The 104B grant research was instrumental for my dissertation because while I was doing the comparative analysis of the two processes of the settlement process and the litigation process, I also had the opportunity through this 104B grant research and funding to spend time and look at each of the 11 Indian water settlements in the state of Arizona. That was a very time-consuming process, very convoluted. I also want to make a disclaimer here that when it comes to dissertations, as I'm sure that many of you know, you can either take a narrow approach and dive really deep into that topic, or you can take more of a broader approach and not dive as deeply into that topic. So I decided to take the broader approach because really the question for the 104B grant process was how have Indian water settlements in Arizona evolved since 1978, and what can that tell us essentially? How can that information from seeing the patterns and the trends within the settlements themselves, how's that affecting them today and the potential future of the settlements? I find it very interesting from an academic perspective that since 1978, there's been a total of 35 congressionally approved Indian water settlements in the entire country, and 11 of those are in the state of Arizona. Um, so that's the gist of the project. For my own purposes, why did I decide to do this research? Why did I want to look at sovereignty and self-determination in regard to Native American water rights? And it's a question about justice, really. Uh, my own disclaimer is that I am an academic coming from the Department of American Indian Studies. So that really allowed me to look at the entire history of how of relations between the United States of America and Native American tribes or tribal nations in the United States. And when one looks at that history, one realizes that really the reserved water rights doctrine, which is the doctrine uh, that drives water rights for tribal nations, it was affirmed by the Supreme Court of the United States in 1908. But yet, still today in 2025, there's many tribes in the United States that lack proper access to water. How's that possible? So that's why I did that research because I wanted to understand, and I think that it's also important for people out there to know the history and understand the context of these rights and why they are so complex. The other thing is that without water, uh, there can't be any life, but also socioeconomic development is very difficult to achieve without proper access to water. So how can we expect tribal nations to thrive as the reservations were originally designed to be their homelands? How can we expect that to happen if the tribes, if the reservations don't have proper access to water? So that's the foundation of my research. For the methods and methodology, so due to time constraints, monetary constraints, and the sensibility of the topic of researching Native American water rights as an outsider, I decided to focus my dissertation mostly on an archival research uh, basis. So I spent a lot of time reading a lot about the history of Native American. So maybe afterwards, once this the slides of this presentation are shared, maybe I can also share a copy of my sources, my references with all of you if you are curious to see where I obtained all of this information. I can also share it with everyone. But there were time constraints when conducting research with tribal nations, researchers, student researchers, I should say, generally they have to go through two institutional review board processes, two IRB processes, one for the university and one for the tribe. And I did some research on that. Initially, I was actually considering maybe doing some field research for the project, but it turned out that it was going to be just too time consuming for my processes. As for the sensitivity of the research, I did consult with tribes. One tribe in particular told me, or folks at one tribe in particular indicated that the topic of water is so sacred and so intimate to tribes that if there was someone from the outside coming to do that kind of research, they would prefer either that the researcher has a stake, a personal stake in that tribal nation where the research is being conducted, or that the researcher partners with a member of that tribe who is also a researcher so that research can happen. So that's really the background of what I had to do and how I came up with the particular research that I did. In regard to water rights, I ended up reading 40 books, journal articles, law journal articles, and of course the 11 Native American water settlement acts in Arizona. I did not look at the settlement agreements, so I acknowledge that there may be gaps in my research because again, I wanted to do a broader view of the research and I didn't get to look at the agreements. So the settlement process essentially is the pre-negotiation. There's a negotiation among the parties, and a settlement agreement emerges from that. And then it gets turned into an act, into a bill that gets sent to Congress, and then it gets debated in Congress, and more negotiations happen, and then it becomes law. I did not look at anything other than the settlement acts themselves, that final product coming from Congress. It's also important to acknowledge that when it comes to the settlements, the fact that they become an act, that they become approved by Congress, doesn't mean that it's over for that particular settlement. If the settlement emerged out of litigation, for example, it gets sent back to the state, and then the state court has to issue a decree. If there are parts of the settlement that require changes in state law, in state water law, for example, or additions, then there has to be legislation at the state level also. So that's the complexity of settlements. But again, when I was doing this research, in particular regarding the 11 Indian water settlements in Arizona, what I wanted to see was how have they evolved since 1978? And there's not a lot of them. There's 35 in total. What are the trends with that? I also want to do a few disclaimers here. Um, the research project was designed to be an educational tool rather than a prescriptive tool. I really don't think that that it's my role as a researcher, as an academic, to come across like I'm judging or trying to tell tribes or other parties what to do. I do think personally that my role is to gather that information, synthesize it, and share it with people so that people can understand uh, these topics that are so important for everyone in the state of Arizona and in other states in the United States. Um, and it's not my intention to disempower or insult tribes. So if I'm just trying to be very careful here to just be as respectful as possible to the tribes that have undergone the litigation or the settlement process. And lastly, the analysis conducted here is based on my own interpretations and not necessarily the interpretations of the USGS or the Water Resources Research Center. So if you hear of any or you believe that there's any interpretation errors, those are my own, and of course you can ask questions at the end where I can clarify anything. Now, um, some of you who have seen my presentations before probably know this, that I really love to share the background of the historical background of the problems that we have today, because really usually that's where the roots are in history. In in particular, when it comes to water rights, Native American water rights, in order to understand why they are the way that they are today, one also has to place them in the context, in the historical context of how the United States came to be, how the United States as a nation began and developed to the nation that it is today. Uh, so History 101, of course, we have the original 13 colonies. And then after the Revolutionary War in 1776, the Ohio Valley opened up for settlement for beyond the boundaries of the original 13 colonies. But then the country, the United States, started to swiftly expand westward through wars, purchases, treaties that they made with tribes. Louisiana Purchase, for example, 1803. The United States went into war with Mexico. This territory over here, this brown part or orangish part, used to be part of Mexico. And then in 1848, Mexico ceded it through the Treaty of Guadalupe Hidalgo. 1853 was the Gadsden Purchase. I don't know if you can see my cursor here, but I mean this is Arizona right here, and that's relevant to us. It's also relevant to know that Arizona was a territory between 1863 and 1912. Uh, so the state itself evolved in that context, and we're talking. I also want to acknowledge that the Spaniards were there, were here in this area from the 1500s onward. But when the United States took over, the laws of the United States were the ones that took over. Uh, and we also have to acknowledge that the prior appropriation doctrine, for example, it 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 started to emerge in the latter half of the 1800s. So again, this history that's happening. Another thing that I want to acknowledge here is the concept of the trust doctrine. A lot of times when we hear about Native American water rights, that concept of the trust doctrine gets thrown around, and sometimes people don't understand what the trust doctrine means. And really, the trust doctrine goes back to Cherokee Nation v. Georgia, which was a Supreme Court case in 1831, um, which essentially said that tribal nations were domestic dependent nations to the United States. And therefore, the United States had this trust responsibility. It's also tied to Worcester v. Georgia, which happened in 1832. And the ultimate decision for that was that although tribal nations are domestic dependent nations to the United States, they are still sovereign nations themselves. And that means that states can't encroach on the sovereignty of that nation. Of course, there's been erosion of that since then. There's been several periods throughout history where that concept of the boundary between states and tribal nations has become blurred. Um, there's Public Law 280, for example, in the 50s, which allowed states to have certain types of jurisdictions over tribal nations. But in general, that's where the trust doctrine comes from. Also, the Indian Removal Act of 1830 is very important because water rights are based on the reservation. Uh, and the vast majority of the reservations are located west of the Mississippi. Why? Because in 1830 there was this act, the Indian Removal Act, which essentially said that the tribes that lived east of the Mississippi River had to move west of the Mississippi River. At that point, they had this area called Indian Country, which is now the state of Oklahoma. But as you can see, this contemporary map here with the reservation land base, that's why you see the vast majority of reservations in areas west of the Mississippi River. So again, the context is very important because as the United States was expanding and it was creating, it's very important. Also, the reservations where a lot of these reservations were established in the 1860s, 1850s. So the reservations are being established by treaty a lot of the time, later by agreement, also executive orders. Um, at the same time, the reservations were being established to be the homelands, the permanent homelands of the tribes. The United States was also passing legislation to incentivize the settlement of by Euro-American settlers of the West through acts like the Homestead Act of 1862, the Desert Land Act of 1877, which essentially uh, incentivized settlers to come to the West and to economically develop the region. But one thing that I've read many times in legal documents is that in the West, land has no value without water. So that's how the prior appropriation doctrine emerged because there wasn't as much water in the western part of the country. So if someone wanted to have a farm, or if they wanted to have a mine or a ranch, they needed to find a way to get that water from the river to to the place where they were establishing their business. Um, there's other laws here that are taking place. Allotment Act of 1887 is very important to today's tribal life, reservation life, because it dramatically decreased the tribal land base of these reservations. For example, out here in South Dakota, this used to be a giant reservation for the Sioux Nation, the Great Sioux Nation, but it was broken up by uh, abrogated treaties and also by the General Allotment Act of 1887. Scholars of Native American studies have estimated that over 90 million acres of land were lost due to this one act, the General Allotment Act of 1887. So the rise of the Winters Doctrine. I already mentioned the prior appropriation doctrine and how it was becoming a thing. And the thing about the prior appropriation doctrine is that the general rules, I will just mention a few rules because they pertain to the reserve rights doctrine, the reserve water rights doctrine, or the Winters Doctrine, is that to make a claim back in those days, to make a claim of water rights, the person making the claim had to either make a public announcement, or they had uh, to make a significant investment in diverting the water for that purpose. And the water had to be appropriable, meaning that no one else had appropriated that water. And there were junior and senior water users. The priority date of that particular water right was the date when the diversion was made, when the claim was made. Also very important, under the prior appropriation, water rights can be lost due to non-use. So that's a difference that we see between the prior appropriation doctrine and the reserve water rights doctrine, about which I will talk in the next slide. But I just wanted to mention that by the 1890s, there were significant water conflicts happening between tribes and settlers, because again, remember the Desert Land Act and the Homestead Act, for example. And tribes were confined to their reservations. But if they depended on a river, for example, the Gila River Indian community, um, Dr. D. Young, who's a frequent guest at the WRRC and also a graduate from the American Indian Studies Department, has written extensively about how the Gila River Indian community came close to extinction in that period of between the 1890s and the early 1900s, because they depended on the Gila River for farming and their livelihoods, and upstream appropriators were diverting too much water, so the river dried up, and there was also a drought in that period. So something similar was happening in Montana at the Fort Belknap Indian Reservation, and that's where we get Winters versus United States, because they were upstream in the Milk River in Montana. There were upstream diverters that were diverting too much water. The case made its way to the Supreme Court, and of course, I apologize for just brushing through this. There's a lot of history here. But the gist of Winters versus United States is that the tribe won. And the Supreme Court said that even though tribes did not reserve water for themselves when they signed treaties with the United States and established their reservations, the water rights were implied, because there was no way that the tribes would have given up their water rights knowing that they wanted to make a permanent homeland in the arid West, where there's not a lot of sources of water. That's essentially the gist of Winters versus United States, and that's the birth of the reserve water rights doctrine. Three doctrines of water law. I'm not going to spend too much here, except that the reserve water rights doctrine, based on Winters versus United States, it shares similarities with the prior appropriation doctrine, in the sense that the priority date of the water right is when the reservation was established. So, for example, we have the Navajo Reservation was established in 1868. That's their priority date. So that's why in the state of Arizona, we have a lot of tribes that have very senior water rights because of that. The water rights are also not lost due to non-use. But conversely, there's restrictions about the uses, the primary uses of the water. And of course, the riparian doctrine is the water law that drives water rights in the eastern part of the country. One important thing about the reserve rights doctrine between 1908 and 1963 is that not much happened. There were very few cases that obtained water decrees for tribes. But obviously the decrees were not enforced properly or implemented properly, because even though the decrees exist, there was still protracted litigation that happened afterward. And a great example of this is the Globe Equity Decree of 1935 in Arizona, which granted water rights to the Gila River Indian community and the San Carlos Apache tribe. As you will see later on, both the Gila River Indian community and the San Carlos Apache tribe have settlement acts. They settle their water rights. And again, what that says is that even though we have this decree from 1935, there was still protracted litigation that happened after that, and up until the late 20th century and the early 21st century, to settle those rights. 1963 is very important because that's when the first Arizona versus California was, like in legal terms, Arizona versus California 1 was adjudicated by the Supreme Court. And there were several results from this. In particular, it's the prior, well, in particular, the practicable irrigable acreage is what came out of Arizona versus California, which is a method to quantify Indian water rights. And essentially, what that means is that the tribe has to prove how much practicable acreage they have to irrigate, and that determines how much water they're going to get. The McCarran Amendment is also important for water rights because it essentially says that tribes have to undergo the litigation process in the state where they're at. So tribes in the state of Arizona have to litigate their cases in the state of Arizona. Initially, the McCarran Amendment did not apply to Native American reserve water rights. It was a series of Supreme Court cases that led to that ultimately. One in 1971, this one, United States versus District Court in Eagle and for Eagle County. Then in 1976, Colorado River Water Conservation District versus United States. And then ultimately, Arizona versus San Carlos Apache Tribe of Arizona in 1983. Those three cases, and in particular, the one from 1976 and the one from 1983, were the ones that where the Supreme Court of the United States said, yes, actually, tribal water rights, or the McCarran Amendment does apply to tribal water rights. So that's the environment where tribal water settlements come in. The first tribal water settlement that was approved by Congress happened in Arizona in 1978 through the Action Water Settlement Act. And as I said previously, there's been a total of 35 congressionally approved Native American Water Settlement Acts in the state, in the United States, and 11 of those are in Arizona. So generally speaking, Native American settlements have been characterized by their flexibility. So for example, if a tribe litigates their water rights in the courts, they may get a water decree, but it mostly stays in paper because there is no funding associated with that. There's also a lot of restrictions through the courts. For example, the court determines what the use of the water is, or the purpose of the water, I should say. The court also restricts the tribe to only use their water rights in their reservation, whereas the settlements, they allow for negotiation for more water uses, or broader purposes for the water rights of the tribe. There's also flexibility where the tribe can conduct off-reservation water leasing, and there's also federal appropriation for funding. So when it comes to the settlements, there's project-based settlements. There's also fund-based settlements, and there's hybrids that mix both funding and projects into the settlement. So that makes them more complicated. An important thing to know about the settlements is that most Native American settlements began through litigation. And that's why once the Settlement Act becomes law, then it has to go back to the state, and there has to be a final decree by the court in those cases. So there are 22 federally recognized Native American tribes in Arizona. And to date, 10 Native American tribes have either partially or fully settled their water rights in the state. We can talk about that later. I remember when I defended my dissertation, there was a question about why did I think that there were so many settlements in the state of Arizona, and there's a lot of theories, but really it's the high number of tribes, in my opinion, and also the fact that there's not a lot of water, and there's a need for the state and also the tribes to have more water security, especially as we deal with climate change and droughts, severe droughts. There's also pending water settlements. I believe there's two in the state of Arizona, but the main one that I looked at when I was doing my research was the Northeastern Arizona Indian Water Rights Settlement Act. It's still pending in Congress, and who knows where that's going, because across the board, one of the greatest obstacles for settlement acts is the cost of implementation. And if I'm remembering correctly, the Northeastern Arizona Indian Water Rights Settlement Act was requesting funding in the $5 billion ballpark, so to speak. So very, very expensive. There's been escalation of costs. And now we get to the fun part about the settlements themselves. Just checking the time here. So these are the settlements that have been congressionally approved in the state of Arizona. So we have the Action Indian Community, Tohono Nation, Salt River Pima Maricopa Indian Community, Fort McDowell Indian Community, San Carlos Apache Tribe, Yavapai Prescott Indian Tribe, Sunai Indian Tribe, Gila River Indian Community, White Mountain Apache Tribe, and Wallapai Tribe. So here's where the trends really will become interesting to me. And again, when I say interesting, it's more from an academic perspective, interesting. What I find interesting about this particular table is this part here, the part about the enactment, the enactment of date of the settlement and the amendments that took place. Because if you look at this part, almost all of the settlements in the state of Arizona, settlement acts in the state of Arizona, have been amended at least once. So the question would be why? Why did they get amended? Some of them are easy. When you look at the amendments, you see that maybe they wanted to amend technical language. In other amendments, they expanded the water uses of the water rights for that tribe. In other instances, monetary amendments. They also, some of the amendments expanded deadlines, for example. Those were some of the things that I saw. But what has me curious is these two settlement acts, the Sunai Indian Tribe Water Rights Settlement Act and the Gila River Indian Community Water Rights Settlement Act, from 2003 and 2004, respectively. And they have no amendments. And it's been a while since 2004 and 2003. So I'm curious what makes these two settlements different than the rest. I don't think that it's appropriate to scrutinize the Wallapai tribes settlements, these two settlements from 2014 and 2022, because the Bill Williams River Water Rights Settlement Act was mainly about a dispute with a mining corporation. Um, and in this one, the one from 2022 is it's too soon to be wondering whether there's going to be an amendment down the line or not, because uh, the implementation process of settlements is very complex and it takes years from what I've heard. So the analysis of how have they evolved over the years? Um, Generally speaking, they regarding water uses and whether the tribes can lease or sell their water rights outside of the reservation or transfer the water rights. The settlements across the board have grown more flexible, vastly more flexible. But at the same time, they have grown more complex. And you can see that from the length of the settlement acts themselves, where they have grown lengthier. And of course, they have grown lengthier because the technical language of the settlement acts themselves has become much more complex. I will show you some tables coming up, but that complexity comes with more restriction. And I'm not a lawyer, I'm a researcher. I'm sure that if I were a lawyer, maybe I'd be wondering, contracts law, for example, why the language has become more technical. I'm inclined to say that maybe they want to cover all of their bases, and they want to avoid having too many loopholes. But that's mostly conjecture on my part. I will show you some of the language in the following slides. An important thing here about the settlements is that each settlement has a section called the waiver section. And that's the section where the parties involved in the settlement, which, by the way, the parties are the state, the tribe, and other stakeholders and rights holders involved, and the United States, of course, through the Department of the Interior. So when looking at that section of the waivers, the waiver of rights, it appears that tribes give away some of their rights. And that's where I feel like some tribes, and I have um, interacted with some tribes outside of the Southwest. These are tribes in the Midwest, in the Plains area of the United States, that they abhor the idea of entering into a water settlement. They strongly dislike the idea of quantifying their water rights. And I suspect that it has to do with the waiver section of the settlements that exist, and also the long history between the tribes and the United States, where the United States has violated and abrogated the vast majority of the treaties and agreements that it entered into with tribes. I would say that a difference between the settlement acts of today and the treaties of the past is that the treaties of the past only had two parties, the tribe and the United States. And as the United States grew in power and the tribes grew less empowered, so to speak, the United States had an advantage where it could violate the treaties without consequences, because there was such an imbalance of power between the tribe and the United States as the United States began growing in power. But with the settlement acts, there's a lot more parties. There's the states. There's conservation districts, irrigation districts, cities. In regarding Arizona, for example, one of the reasons why settlements are so important is because it's not good for the state to have so many unclaimed Native American water rights out there floating around. It's better for the state to know exactly who has what rights to how much water so that they can plan better. And also for the tribes, it's better for them to know how much water they have. But there's issues, there's history. That's why I spent so much time in the beginning with the history. There's a lot of what some people would call in layman terms, a lot of baggage with this history, and there's a lot of distrust where tribes are saying, well, am I going to end up losing more if I go through this settlement? But the alternative is litigation. Again, I'm not saying making a judgment of whether litigation or the settlements are better. I already said which one I think affords the tribes greater sovereignty and self-determination, but still, there's a lot of questions and a lot of doubts that have to be overcome from the tribal side. Now, here are these tables. I have two tables that I want to share with you before I conclude. And I just wanted to show you how the uses of water have changed over time. So, for example, we have the Action Indian Community Act of 1978. At first, the uses of water in 1978 were allocated for irrigation. And then in the 1984 amendment, it said that the water could be used for any use. And then in the 1992 amendment, it said that the water can be leased outside the reservation, but only within the Tucson, Pinal, and Phoenix active management areas. So that's another important thing about these settlements is that they have been evolving in conformity to the evolving water law of the state of Arizona. So of course, the active management areas are tied to the Groundwater Management Act of 1980, and of course, one thing about these settlements is that whenever there's a settlement, whenever the negotiations are taking place for the settlement, there has to be a source of water for that particular settlement. And Colorado River water has been a source of those waters. Not all the time because there's been water exchanges, but still CAP water or Central Arizona Project water is pivotal for these settlements because even when there's water exchanges, usually the exchange happens between waters that cities already have allocated to them and CAP water that gets exchanged to them. Again, White Mountain Apache Tribe Water Rights Quantification Act, for example, cap water may be used for on or off reservation for any purpose. But again, the restrictions, cap water may be leased or exchanged in the counties of Maricopa, Pinal, Pima, and Yavapai. Tribal water may not be used outside of Arizona. The one that I find interesting here is the one for the Gila River Indian community because they have a very large water decree or water allocation that they obtained from their Settlement Act. And part of that water comes from the CAP project or cap water, but other sources of that water that they received comes from the Globe Equity Decree, the Haggard Decree. So just to see the uses of the water for the Gila River Indian community, cap water can be leased, distributed, and exchanged. The water may be used outside the reservation for community purposes. Okay. And then the restrictions is that cap water may be leased, exchanged, or allocated within the counties of Maricopa, Pinal, Pima, La Paz, Yavapai, Gila, Graham, Grimley, um, so on. But then it says the water may not be leased or exchanged outside of Arizona. And then any waters obtained through the Gila River Agreement, the Globe Equity Decree, the Haggard Decree, may not be sold, leased, transferred, and used outside the reservation other than exchanged. So again, these are the flexibility we can see from this chart, the flexibility within the settlements, but also the restrictions that they have for the tribes. And then lastly, I have this table of Native American settlement and rights waivers in Arizona. I put excerpts here because this is not the entire table. And in fact, I have another part of that table that I wanted to show you because that table is big. And when I tried putting the entire table in the slide, it became useless because it was so tiny and compressed. So I just put a few here. But a notable thing about the waivers is this, this language over here. Waiver of any and all water claims from time immemorial to the present against the United States, Arizona, or any other agency, person, corporation, or municipal corporation. That's what the tribe waived with the Action Indian Community Act. And you see that language throughout. You see it here with the Tohono settlement from time immemorial to the date of agreement signing. There's fluctuations and differences in the settlements. But then what I want to show here is those are I already mentioned why they can be problematic, but they have been growing more restrictive. So you see the restrictions here, and these are acts from 1992, were amended in 1994, 96, and 97. But the Wallapai Tribe Water Rights Settlement Act of 2022 has a lot of waivers. And again, I wonder why so many waivers. So I'm not going to read them too much because I do want to leave time for the question and answer. You can read them afterward, but there's waivers and releases of claims by the United States as trustee for allottees, waiver and release of claims by the United States against the Wallapai tribe. So it's not just the tribe that's waiving and releasing claims against the United States or against the state of Arizona or against party X. It's also the United States waiving claims. So again, I find that this interesting from an academic perspective. And this essentially concludes my presentation. I do think that the settlements offer an opportunity for tribes to regain some of their lost sovereignty, but at the same time, they can be problematic, especially regarding the rights that the tribe gives up. And again, as a researcher, as an academic, I don't think that it's my prerogative to judge whether that's appropriate or not. It's up to the tribe. I've seen some tribes that love the concept of the settlements, and I've seen some tribes that strongly, very, very strongly dislike the settlement process, and that must be respected when it comes to this. And again, whenever discussing Native American rights, I think that it's fundamental to understand the history, where those rights come from, because that can help people open their minds more and understand where people are coming from, not just non-Native Americans understanding the history, but also Native Americans themselves understanding their history. So this concludes the presentation. I would appreciate any questions, and thank you for listening.
Wonderful. Thank you so much, Dr. Menjivar. Yes, thank you. I see rounds of applause coming across. So yes, thank you for this very informative webinar. Please feel free to pop any questions you have in the chat and we can moderate from there. I'll just back up a bit to an earlier question. Kevin Black mentioned a copy of the presentation. So this webinar is being recorded and it will be posted on our website as well as a PDF of the presentation. And we'll see if we can work with Dr. Menjivar to get a copy of her resources, or you can be in touch via email and she can send those out. Um,
I can I say something? I can even share a copy of my dissertation if you want it. I have it embargoed right now because I'm um, writing an article with Dr. Megdal, and Professor Heather Whiteman runs him at the law school, that based on this research. But if you want to see a copy and all of the research, I can also share that with people if people are interested.
Great, thank you. And then there was a question, although I think it may have been answered, but Michael Carpenter early in the presentation was wondering about on the Navajo Nation where there's still significant lack of water. The question is, didn't the Supreme Court rule against them recently in spite of the Winters Doctrine? So you did talk about the Northeastern Arizona Indian Water Rights Settlement Act. I don't know if there's anything else you wanted to say about that.
The thing to say about that, yes, there's the pending settlement in Congress, and yes, the Supreme Court decision in 2023 was very problematic. I did write about it in my dissertation, because there's a significant erosion of the trust doctrine. There's also important aspects of what in legal terms people call the canons of construction of American Indian water rights lie with a case in 1905. It's United States versus Winans, and of course Winters versus United States in 1908. And the precedents set in those two cases were ignored by the justices. I I don't want to go too much into the weeds of that right now, but there's a settlement, and this gives me the opportunity to also say a major criticism that I've seen against settlement, the settlement process, is that there are some scholars out there who say that the settlement process is coercive because the Navajo Nation has settlement acts in New Mexico. There's the Navajo Gallup project where they have water. And from things that I've read, and these are classes, don't quote me on these because I'm just remembering from the ether of my mind, is that initially the Navajo Nation wanted to build a canal and bring some of that water from the Navajo Gallup project to Window Rock. And they were not allowed to do that by the state of Arizona. So again, there's criticisms against these settlements. They are very good. They provide wet water for the tribe, but there's drawbacks.
Yeah, thank you. And thank you also, Sharon posted in the chat. Thank you. And apologies for confounding. The Supreme Court decision is distinct from the Northeast Arizona Indian Water Rights Settlement Act. So apologies the way I phrased that. And Aminta has addressed that. Aminta, would you be okay putting your email in the chat there,
Of
folks?
course.
The
Yeah, yeah.
presentation? And also, Crystal Tully Cordova asked about the tables that were shared at the end of the presentation. Are those in the dissertation, or is there?
Yes, they are in the dissertation, and also, of course, I'm assuming that the slides will be shared with
Yeah, so we'll
the
post the PDF of the slides. Those will be
yeah.
available on the website. And give us a couple of days, but we'll get them up as soon as we can. So please check back. And for those who've attended today, you should receive an email letting you know when the video is posted, and then you'll know that it's available on the website. Um,
Here.
Let
Aminta,
me,
I can put your email in the chat unless you wanted to use a different one than the one I have for you.
No, the Arizona.edu email should work. I can also put it in there if, yeah.
I got it.
okay, great, thanks. Um, and I'll just read these as I see them. From Jean Reitz, the 7 basin states have not been able to reach consensus on future management of the Colorado River. How does that uncertainty relate to the settlement of Indian water rights?
Well, the thing about the 7 basin states is the the 1922 Colorado River Compact did not include Native Americans in the negotiation process, and that's a significant flaw. There was only one reference to Native Americans in the Colorado River Compact of 2022. Sorry, not 2022, 1922, where it said that nothing in that compact would affect the water rights of tribes. Um, but of course, it affects the water rights of tribes because water is managed at the state level. And as we saw with both, so the McCarran Amendment compels the tribes to litigate their water rights in the state where they're located at. So Arizona tribes must go through the Arizona courts to litigate their water rights. But the settlement process also compels them to negotiate with the state. So either are you going to go through through a very contentious litigation process, combative litigation process with the tribe with the state, or are you going to see if you can negotiate the water rights? But where the water shortages or negotiations affect tribes is that, for example, Arizona has 2.8 million acre feet of water from that compact, right? And out of those 2.8 million acre feet of water, some of that water has to go to the tribes. So that's where it affects the tribes is how much water does the state have to allocate amongst everyone? Tribes, cities, irrigation districts. That's really where the rubber hits the road and regarding water rights for tribes and how much water there is.
Yeah, thank you. And Julia Fonseca has the hand raised. Go ahead. Yeah, please.
Yeah, thank you. First of all, thanks for this really lucid description of Indian water rights. It's really helpful.
Thank
Mainly,
you.
I want to know about the SAWARSA agreement, the amendments that you mentioned. At one time, there was a groundwater buffer, and then I think it went away. The groundwater buffer around San Javier district as part of the
Mm-hmm.
SAWARSA agreement. And I think it went away. And could you comment on whether that's true and why would that be? Any idea?
Now, yeah, go ahead. Was that it, or did you have
That's
something
it.
else? Okay.
That's it. Thank you.
Yeah. Well, there's a limit to how much water the tribe could pump, and I believe off the top of my head it was around 10,000 acre feet of water per year that they could pump. This is where the weakness in the research lies, is that yes, I did read that, but mostly I was looking at patterns, at broader patterns. So I wouldn't be able to answer off the top of my head whether that went away or not. I know that it was there initially, like you said. Um, but in my dissertation, I do have I have two appendices, Appendix A and Appendix B, and that information is there.
Okay. All right.
Yeah,
Well,
thank
great.
you.
Thank you so much.
And Sharon just noted in the chat that she did not know that the buffers were taken away.
Well,
Yeah.
I could be wrong, but
No,
my
I'm just,
recollection.
yeah, I'm just saying I unmuted that I didn't know that. And that's very interesting, Julia. If they did go away, there were also groundwater pumping buffers, if I remember correctly, as part of the Gila River settlement, Gila River Indian Community settlement, in terms of the agricultural districts in that area. And I'm not expert enough to know if any of those had time limits to them. That's an interesting question.
Yeah, I can find the answer for you and get back to you if you email me so that I can have your email.
Great, thank you.
And Dr. Menjivar, I just want to draw your attention to is a compliment, amazing presentation, and thanks for that. And then a note from Tania Arbalo, excuse me if I pronounced that wrong, but sounds like maybe you should be in touch to connect about sharing your work as well as potential collaborations there. So if there's any trouble connecting, feel free to reach out to us here at the WRRC, and we can make sure we connect you with Dr. Menjivar.
Yeah, absolutely. I mean, one of the things that I've discussed with Dr. Megdal and other people in my circles is that there's questions. I mean, on paper, these settlements do appear to be good for tribes, generally speaking. And I wonder, once the implementation process takes place, are they really that good? So there's a gap in the research where there's really a need for people to partner for researchers to partner with tribes and investigate this. How are the settlements getting implemented? What kind of snags are you hitting now that you didn't foresee when you were negotiating the settlement, for example?
Great. And I do want to recognize we do go until 1:15, so we do have time. And Sharon, yes, go ahead, please.
Well, I was just going to note one thing, just we usually have a very mixed audience, and I think if you want to ask the questions, how did it turn out? I think the answers to that will depend on to whom you speak and when you're speaking with them, because a key component of the water settlements has been, and I think Aminta, you mentioned this, some of Arizona's entitlement to Colorado River water, and some of that is of a lower priority than the Indian priority. Sometimes there's NIA water that's included in that. And with what's happened with the aridity and lower flows on the Colorado River, the firmness of the water is maybe not as secure as people thought it would be. So I think it would be very interesting not to just do it at a point in time, but maybe to ask some questions if people were willing to share over a period of time to see if views changed. I think it could be very interesting.
Mm-hmm. And that really reminds me is that's thank you, Dr. McDowell. It's that tribes, as I mentioned in the historical part of the presentation, they have very, generally speaking, of course, not all of the tribes, but generally speaking, tribes have very senior rights, what's called present perfected water rights in Arizona. But Colorado River water through the Cap Canal to the Cap Canal itself, it has junior water rights. And I wonder too, what happens when the tribe, because throughout the settlements you see cap water. There's that one question, but then there's another question, which is the firmness of the water. Because what's happening is that a lot of the later settlements actually don't have that water, that cap water. Usually there's water exchanges and that get done between the negotiation where maybe this one city will give up 10,000 acre feet. Of course, don't quote me on that. That's just an example. But this one city will give up 10,000 acre feet of their non-Indian irrigation water rights, and that water will be allocated to the tribe. And again, how secure is that water when we are facing drought? So that's what I'm saying is that with the settlements, there are tribes that want the settlements, but there are tribes that I've talked to that actually, when they invite me to go and talk and give talks, they tell me that they even have this disclaimer: we are not advocating for water settlements, like literally, because they don't like settlements. I mean, it's the lay of the land with this.
Thank you. I do want to recognize the comment there by Ray Benally. I'll just read it out loud, and then if anyone would like to respond, including Ray, please feel free to do so. But it's related to the buffer zone conversation. A buffer zone at southern Navajo Nation, I believe, boundary was part of the initial proposed settlement that wasn't accepted by the Navajo Nation and Hopi. That buffer is not in the new proposed settlement.
Thank you for sharing.
Some good things to follow up on here. Great. Well, we do have 5 minutes left. So I'll give it another minute just to see if there are any more questions or any final comments. But we can also wrap up today. And let's see. Yep. Jesse's just again posted the link where you'll be able to find the slides and the sources. And so please join me in again thanking Dr. Menjivar for this excellent presentation. And we hope to see you at our next webinar.
Thank you.
Thank you.